We are seeing people who are engaged in civil disobedience, public protest, peaceful assembly, and a whole bunch of other acts that are protected and enshrined in our charter being withheld bail when we've got folks who are dangerous criminals getting out and stabbing people on the, public transit in Toronto, getting out of jail and shooting up streets and hitting innocent bystanders. It's an affront to justice.
Sydney Vizard for Rebel News. Anthony Oleanic, Chris Carbert, Chris Lysak, and Jerry Morin were charged with conspiracy at the Coutts blockade and are expected to be back in court on July 25th, 2023 for what is expected to be a pre-trial hearing. Arrested on February 13th and 14th, 2022, these four men have now spent in excess of 500 days in pre-trial custody. Many argue the rights of a timely trial and bail have been violated for the accused. All four men were denied bail, with reasoning hidden by a publication ban. Anthony Oleanic, Chris Carbert, Chris Lysak, and Jerry Morin were arrested during the execution of warrants by RCMP in the town of Coutts on February 13th and 14th, 2022. They face charges of conspiracy to commit murder, possession of a weapon for dangerous purposes, and mischief over $5,000. This coincided with the Freedom Convoy to Ottawa and the Coutts blockade, both part of a national, unparalleled, peaceful movement against vaccine mandates and COVID restrictions. Upon news of RCMP's executed warrants, Coutts blockade supporters decided to end their 18-day highway demonstration to solidify their message that this was a peaceful protest. In Alberta, the movement was so impactful that the former Premier Jason Kenney, whose own party voted him out, lifted vaccine mandates during demonstrations. Not 24 hours after these men were arrested, Justin Trudeau invoked the Emergencies Act in order to bring police enforcement onto peaceful demonstrations across the nation. In June, the four men appeared in court. They were expected to appear for a 2 to 3 week jury trial, their trial, which was delayed due to pre-trial applications brought by the defense. Lawyer Greg Dunn, representing Jerry Morin, requested an adjournment on June 13th, alleging prosecutors haven't fully disclosed evidence of the police investigation. Dunn has called this a failure to disclose a violation of the accused's constitutional rights. They are expected to be back in court on July 25th, 2023 for what is expected to be a pre-trial hearing. Trial dates for the four men have yet to be determined. We interviewed Chad Williamson of Williamson Law, a barrister and solicitor who has assisted Rebel News and the Democracy Fund in the legal defense of many who were charged or ticketed during the Coutts blockade. Chad is not legal representation for any of the accused, but was able to speak as a lawyer about the judicial system. How common is it for individuals in Canada to be held in pretrial custody for in excess of 500 days?
It's absolutely exceedingly rare, except for typically most of the heinous and shocking of crimes. So the fact that we are seeing people who are engaged in civil disobedience, public protest, peaceful assembly, and a whole bunch of other acts that are protected and enshrined in our charter being withheld bail when we've got folks who are dangerous criminals getting out and stabbing people on the, public transit in Toronto, getting out of jail and shooting up streets and hitting innocent bystanders. It's an affront to justice, and it's disgusting, and something needs to change. I think at the legislative level, because I don't necessarily know that this can be fixed in the courts. I would hope that the judiciary and those sitting on the bench would revoke or would grant bail based on some common sense and based on reason. And in many cases, we're not seeing that. We're seeing insane bail revocations for peaceful acts of civil disobedience and protest. And then we're seeing leniency for people who are dangerous and who are out in public hurting people and committing real violent crimes against the population. It's pretty disturbing, and it's an affront to justice.
And it's not just concerning in the fact that there's perhaps a double standard, but as well, there is a right to timely access to justice. Is that fair to say?
Definitely. And I mean, there's an old saying that the wheels of justice grind, but they grind slowly. It seems that saying only applies to cases in a very select way. Now, criminal cases are extraordinarily complicated, and one thing that people do need to remember, especially in criminal proceedings, is that we don't get to see the entire open book and really understand what's happening, especially if there are sealed proceedings, especially if there are defense strategies employed that for potentially the protection of the defendants, the criminal defendants in those actions, they don't want that to move ahead quickly, requiring further examination. One great example is in many of the fight the fines cases, the Crown Prosecution Service really wanted those to move with a degree of haste so that they could just close the book on these people without, potentially affording them due process. Sometimes it's up to the defense lawyer to slow down the wheels of justice so that due process can take its rightful course and that the prosecution can properly be tested and the burden of proof adequately be reviewed by the court and by counsel.
And in terms of a trial by jury, anything that happens before that during the case, like pre-trial meetings or anything like that, these are all protected under a publication ban. Is that correct? Generally speaking, so that the jurors aren't seeing this evidence that they shouldn't be.
It's a little bit more complicated than that. It depends on whether or not a publication ban has been requested. People often jump to the conclusion that if there's a publication ban, that it's the government or it's the prosecution service that's trying to keep something under wraps so that the public doesn't know about it and, that they're doing some sort of, secret trial. In many cases, a publication ban can actually be an application that the defendants make. And again, specifically not to taint the jury pool, maybe to potentially protect the accused. In other proceedings, often when we've got multiple people that are also accused in the same proceedings, they might not have the same interests as one another, depending on, their alleged role in whatever the alleged crime was. These cases are often very, very complex, and things aren't often as they seem. A great defense lawyer will use every tool at his disposal to protect his client. And in many cases, they do that. And from the outside, it's kind of hard to understand exactly what's happening. But we do have some great defense lawyers in Canada, and I have faith in many of them.
Given that you require disclosure, which is the evidence against your client, to present the case for your client, what kind of issues can that cause when disclosure is either delayed or partially provided?
Well, in Canada, there's a couple different laws about disclosure. One of the big ones is a case called Stitchcomb, which requires the state to make full and frank disclosure of everything involving their investigation and surrounding the charges, the good and the bad, which could include exculpatory evidence. And what that is just evidence that actually helps the defendant or show their innocence. So they have to turn over everything. This is a fundamental aspect of criminal law and especially of criminal defense law. Now, just to give you an example, in the Chris Scott case, this is one that we've been fighting over disclosure for almost a year now, when it actually turned up in trial that Alberta Health Services had a whole bunch of emails that related to the investigation and prosecution of Chris Scott, and that they didn't turn it over. We made an application on the spot during the trial, and it's still taking another year to go through that. We did get the emails, but upon receipt of the emails, we thought that there could be additional disclosure now that was mentioned in the emails that they didn't provide. So these disclosure issues can really turn into very large, what we call interlocutory matters, where the defense doesn't feel that the state has provided all of the information relevant to the charges in the investigation and relevant to the case, to the defense, which they're required to do. So these disclosure issues can be serious. Disclosure issues are big, and if you don't comb through the disclosure in a fulsome and complete way and with an investigatory mind and perspective, you might miss something that is exculpatory that could actually assist in the defense of your client.
We will be following this story as new developments occur. To see the latest, go to rebelnews.com. For Rebel News, Sydney Fizard. If you want to see our previous reports on the 4 men charged with conspiracy at the Coutts blockade, go to rebelnews.com.